This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
Now I will pass it on to one of our very own, Gideon Kracov, who will be moderating today's program and will introduce our panelists. Gideon?
Thank you, Hayward. Good to see everyone here today. Welcome to Earth Day Masterclass, Environmental Dispute Resolution Strategies. And let me take a moment here to introduce our panel. Richard Toshiyuki Drury is truly a living legend. 30 years ago, as the groundbreaking legal director of Communities for a Better Environment, he put environmental justice lawyering on the map. He's done CEQA, Clean Air Act, housing, clean water, and everything in between. He's the founder of his eponymous law firm in Oakland, Lozeau Drury, where he represents nonprofits, community groups, and labor organizations in these cases, almost exclusively from the plaintiff side. He also has a birthday coming up. Happy birthday, Rich. Kevin Poloncarz co-chairs Covington Burling's Environmental and Energy Practice Group. He is a band #1 listed on Chambers at the top of the profession, with many blue chip, utility, and industrial clients. Kevin is an exceptionally versatile lawyer, called on by his clients in crisis situations, to vet CEQA documents, and to handle matters before the United States Supreme Court. He also teaches at Stanford Law School. Our third panelist, who is finishing up a meeting right now with US EPA Administrator Michael Regan, and hopefully will be joining soon, is perhaps the leading and most experienced environmental prosecutor of her generation in California. Stacey Geis has prosecuted these cases as an assistant US attorney in the Northern District, as vice president of litigation at Earth Justice, and as a state court circuit prosecutor. Now she serves and has been snatched up by the Biden administration in Washington, D.C., as the U.S. Senate confirmed Deputy Assistant Administrator at US EPA's Office of Environmental and Compliance Assurance. And my name is Gideon Kracov. I'm a mediator at ADR Services in environmental, real estate, and civil matters. For identification only, I'm the governor's appointee to both the California Air Resources Board and the South Coast Air Quality Management District, where I employ many of the same dispute resolution techniques, working with stakeholders from all sides as I do as a mediator. I'm also on the adjunct faculty of Loyola Law School, where I teach land use law for many years. So that's us. Happy Earth Day, everyone. It's the 54th Earth Day, Earth Week. Every year on April 22nd, Earth Day marks the anniversary of the birth of the modern environmental movement in the 1970s. Democratic Senator Gaylord Nelson from Wisconsin was concerned about the deteriorating environment. He announced the idea of a teach-in on college campuses and persuaded Pete McCloskey, a conservation-minded Republican, to serve as his chair. So it was bipartisan. It inspired 20 million Americans, at that time 10% of our population, to participate in environmental conservation activities. And by the end of 1970, Earth Day led to the creation of the US EPA. And this era led to passage of other first-of-their-kind environmental laws, the National Environmental Policy Act, the Clean Air Act. 2 years later, Congress passed the Clean Water Act. Earth Day has made a difference. For each generation, each new year, Earth Day asks us to confront new challenges. Today, for California, we need to resolve a housing crisis that requires an estimated 120,000 new units each year, and build infrastructure like grid upgrades and electric vehicle charging to meet our climate goals. This panel, this Earth Day Masterclass on Environmental Dispute Resolution, will investigate how we can get these things done by working together. So just a few introductory slides to set the stage on environmental dispute resolution. At the federal level, we have the Administrative Dispute Resolution Act of 1996 that defines ADR, and you'll see it there. US EPA has a policy on alternative dispute resolution that establishes EPA's Conflict Prevention and Resolution Center. You can explore ADR through the CPRC or any regional ADR program at the 9 administrative bodies. This process can be robust and is used for pre-dispute matters like the aftermath of the East Palestine, Ohio train derailment, or getting the stakeholders together on complex Superfund cleanups. We want you to know that the Department of Interior also has such environmental collaboration and conflict resolution programs for its resource and tribal issues, things like forest and fisheries management. Again, mostly pre-litigation with trained facilitators, mediators, and outreach professionals. One terrific organization that does this work is the McCain National Center for Environmental Conflict Resolution, part of the Udall Foundation at the University of Arizona. There's a lot of theory, technique, and psychology behind this work. Click on some of the links or in our handout materials. Sacramento State also has an excellent program and professionals that do this work. Turning to mediating the litigated case, the federal courts in California essentially require mandatory mediation of all civil cases. Of course, those include your federal environmental matters, Superfund, Clean Water Act, takings. Here are some links to the programs at the 9th Circuit, the Northern and Central District. I sit on the Central District Mediation Panel. It works well, and there are dozens of qualified colleagues, or you can privately hire mediators at firms like ADR Services. For state court cases here in LA Superior Court, there's also a terrific free mediation service called Resolve Law that now, hot off the presses as of last week, is open to all independent calendar civil cases. It's called Resolve Law. 30 years ago, California lawmakers recognized that ADR, and specifically mediation, would aid in resolving land use, environmental, and related public policy litigation. The Planning and Zoning Law, Government Code Section 66030, authorizes permissive mediation in 10 types of matters: CEQA, general plan decisions, mitigation fees, zoning matters, and an expansive catch-all for the approval or denial by the public agency of any development project. Yet today, these decades-old government code mediation provisions are rarely invoked, largely because they're permissive, and most land use lawyers don't even know that they exist. But now you do. CEQA's early settlement meeting process in the Public Resources Code, section 21167.8, also does not meet expectations. It requires the parties to meet and attempt to settle the litigation within 45 days, but the meeting's often pro forma, abbreviated, and does not meaningfully assist in resolving the dispute. And while it's true that that section of code states that if the litigation is not settled, then the court, at the request of any party, can schedule an FSC before the judge, that too often also is forgotten and rarely, if ever, occurs. So have a look, breathe life into Government Code Section 66030 and the CEQA early settlement meeting. Let's do some mandatory settlement conferences and mediation in your cases. Land use, environmental, and related public policy disputes can be complicated and fraught with emotion. It's precisely for these reasons that facilitated mediation can help build trust among the parties, to help meet the housing and infrastructure challenges our state desperately needs to address on Earth Day. And there's an article in your materials on this. I hear sometimes, oh, Gideon, you want people to do this because you're becoming a mediator. But can we flip that? The truth is, I'm becoming a mediator because I want to help people do this. Let's turn now to our master panelists for their environmental dispute resolution strategies and advice. Kevin, there in Big Law, give us perspective from the project proponent side or working on compliance or enforcement matters for your client. Thank you, Kevin Poloncarz.
Well, thank you so much. It's wonderful to be here. This will be the capstone of a wonderful Earth Week. I got back late last night from DC for some wonderful celebrations I'll talk about a bit. I'll start by talking about working with the affected community, as Gideon said, on an infrastructure project. And just to provide some framing, we now have seen such a tremendous emphasis on environmental justice in the Biden administration. And when I teach, I tell my students what I think galvanized the emphasis on EJ at this particular historic moment is two things. First, there was COVID, where we saw the worst outcomes for Black and Brown communities. Many studies linked those to the disproportionate air pollution impacts those communities had long felt. And that coincided with the racial awakening that occurred as the result of the murder of George Floyd. The confluence of those two events really shined a spotlight on how environmental burdens borne by those communities could be linked to bad health outcomes. And the result is that EJ is now ascendant and isn't an issue, forgive me, Richard, that can be addressed just with lip service, as it often was in the past. So if you're the proponent of a big project, a big infrastructure project of any sort, it's not really an option to think you can get your project approved without addressing community concerns. The strategy that I take with clients is not to stick your head in the ground and just hope no one's going to notice, but to really kind of plan and execute what I would consider a robust stakeholder engagement strategy. And this really starts with identifying who is the affected community. This can take some effort. My advice is don't wait until your project is public. Don't wait until you've submitted your applications. Reach out in advance so that the community can have some input and actually help you craft what your project looks like. Make contact before you start submitting your applications and ask to meet with any identifiable community members. When you do that, when you meet with them, don't set what I would view as unreasonable rules for engagement. That only betrays the goals of transparency and finding shared objectives. I could provide a lot of examples, but suffice it to say, when you have these meetings, it's important to go in with your guard down. Don't assume things like confidentiality of the information that's going to be shared, and don't insist upon it. And most importantly, never leave the meeting without asking, who else should I be talking to? You may start with those you know. For me, it often starts with folks in the ENGO community, in the EJ community, but they will ultimately point you in the direction of where you need to go and who you really need to talk to. Find answers to the questions that are asked, conduct follow-up. And when you do this, my advice is set your client's expectations realistically. The goal of this, the ultimate objective, isn't to neutralize parties or to avoid litigation altogether. The outcome ultimately will be a better project. You'll have identified and surfaced the issues. Even if they sue you, you'll have known about those issues since before the EIR has gone to press. Now, just think how many more opportunities that gets you to grapple with the issues. And so that's my advice on dealing with a big infrastructure project. You can move on, getting into the next slide. So in the enforcement context, how do you, like me, as a representative of companies who are facing liability, help achieve an outcome that's better for everyone? First, it's really critically important to understand, like, what are the regulators' objectives and priorities? Are you in an AB 617 disadvantaged community where they're making a lot of effort to provide demonstrable improvements in air quality? Or are they really seeking more fundamental changes in how your client manages environmental risk? And it's really important in many cases, when you have an ongoing violation, the first priority must be correcting that. Don't let your client get distracted by what the ultimate penalties are going to be, what the sanctions are, when they really need to be focusing on taking corrective action. And don't let that deter them from working with the agency to figure out how to actually do that in a way that's going to satisfy the agency. And third, follow the money. It's often important in assessing your settlement strategy in an enforcement context to understand what happens to the penalties if they're imposed by a court versus through a settlement. This isn't so much an issue at the federal level, but in California, often penalties imposed by a court go to like the general fund or some other purpose, whereas if penalties are obtained by an agency through a settlement, they can go to something like the Air Pollution Control Fund, for example, and that's spelled out by statute. And it's really important to understand that, to really understand what the agency's posture is vis-a-vis your client when they're essentially rattling sabers and putting up statutory maximums they could obtain in court. Fourth, as we already discussed, agencies are acutely focused on demonstrating benefits to communities that are impacted. And so they're thinking about how they can bring about more than just compliance. Like, how can they get additional reductions to remedy the past wrongs? How could they improve public health? This can take the form of SEPs, supplemental environmental projects, or other mitigation. And finally, where there's some risk of repeated noncompliance, or there's a risk that your client's not going to achieve their milestones, it's often advisable to include stipulated penalties so both parties know how to resolve this in the future. Last, I just wanted to describe some special considerations that occur particularly when you're dealing with policy disputes at the federal level that span presidential administrations. This is really particularly important because we're in an election year. I just returned from DC last night, where I attended EPA's rollout of carbon pollution standards for power plants yesterday at Howard University. I've been working on carbon pollution standards for power plants for a decade now. And we started back in the Obama administration. They had a signature climate policy for the power sector. It was known as the Clean Power Plan. I represented a bunch of power companies who were defending that rule. We had a 6-hour en banc oral argument a few weeks before the 2016 presidential election. I argued right after DOJ. We felt really good. We thought we were going to win. And then President Trump got elected. The pendulum swung, and when it swung quite radically. The Trump administration came in, they repealed a whole slew of administration of the Obama administration's rules, including the Clean Power Plan. And so then my clients were in the position of having to sue the agency they were arguing alongside of. And fast forward, I had to argue the main statutory point in a 9-hour oral argument in the DC Circuit in October 2020. We obtained a decision issued by the DC Circuit, which struck down the Trump EPA's repeal just before, one day before the Biden was inaugurated. That case ultimately went up to the Supreme Court. We got a decision on the last day of the term of 2022. I won't say much about it other than that the court said EPA had gotten it wrong what they did in the Clean Power Plan. And so now just yesterday, Administrator Regan walked into the room, Bruce Springsteen playing, Born in the USA, to announce the rule to replace that Trump replacement of the rule. And we're expecting litigation again. The reason I provide this context is because as an environmental lawyer who's been working on this one objective, like advancing durable carbon pollution standards, achieving that goal often requires that you navigate the very distinct situation that happens when you have changes in presidential administrations. And you often may find yourself on the opposite side of the lawyers who you were on the same side of at DOJ or EPA. Or you may find yourself briefing at the Supreme Court alongside the DOJ lawyers who were you arguing against below. And the most important thing that I can provide you about how to navigate this is that it's really important to maintain your credibility. My former mentor, her best advice to me was you only have your credibility to lose once. And so you need to earn the respect in these cases of both your allies and your opponents. Don't take positions that are unreasonable. Don't take a scorched earth approach. Be collegial. And when the change happens, it will ultimately serve you and your clients well. Turn it back over to you, Gideon.
Oh, good stuff there, Kevin. What an interesting situation and something you may have to live through again here. We'll see what happens.
I hope not.
Let me ask you a question, if we can go behind the curtain a little bit, Kevin. For your corporate, the industrial clients, what matters most? Maybe you can't generalize, but what matters most to get to a deal in high-profile matters for those clients? Is it the publicity and the external focus on these cases that moves them? Or at the end of the day, is it really just about the financial bottom line? Are there any observations you can make on that one?
Gideon, I hate to be trite, but I would say through my career, what I've learned is that clients who want to do the right thing will do the right thing for the right reason. It may be that there's an business imperative there. It may be because there's a public spotlight shining on them. Or it may be because they just have certain commitments and a mission that push them in a certain direction. But I think it's a mix of all. It's situation specific. But what I've learned in dealing with clients is if the client's got the right instincts and the objectives to do the right thing, you can guide them to the right objective.
And maybe if I can just push back on that a little bit, how do you deal with client authority in those situations where your client may be seeing it a little bit different way than you might advise as a lawyer? What techniques do you use to try to get authority in those types of situations?
It's tough. What I personally try to do is really inform them on all the factors that I described. What are the regulators' objectives? What are the community's objectives? What are the potential outcomes? How do they want to resolve this in a way that's both going to be helpful for them, remove the obstacles they have to their project, get their enforcement action done, and takes a lot of handholding, bedside manner.
That's right. I think one of the things we're going to hear as a constant theme here is the value and the importance of relationships in this work. So, Stacey, you didn't get a chance to hear the glowing introduction that we gave you a few minutes ago. We know you were a little bit late with a meeting there with the administrator, but now we'll turn it over to a government lawyer's perspective, a prosecutor's perspective on environmental dispute resolution with Stacey Geis, the Deputy Assistant Administrator at US EPA's Office of Enforcement and Compliance Assurance. So welcome, Stacey.
Thanks. Can you all hear me?
Yes.
Okay, great. So first of all, I'm so sorry I was late. And yes, I was called to be with the administrator, which anyway, but and it was great. Kevin, I love that you were, I will just say, I love that you were here at Howard University yesterday. I mean, what's going on right now is a flurry of rulemaking at EPA, which for those of you, you may all know this, but I mean, the magnitude and the breadth of the rules that have come out in this administration is just like nothing we've seen in terms of the numbers and the scale. And it's for many of us really exciting. So Kevin, I love that you were there with Administrator Regan and it's funny, I actually was just having drinks last night with actually one of the architects of the Clean Power Plan, Kevin, who was literally telling me, pointing to this was kind of cool about the job, just like pointing me to the table where they actually, several of them came up with the Clean Power Plan. And I love that you have played such a central role in this for the last decade, Kevin, and I just want to say thank you for that. And you bring such an important perspective. Okay, so sorry. And two, I need to say out loud, just I'm here in my personal capacity. Nothing I say here today is at all a reflection of the Biden administration or EPA, but I'm thrilled to be here to talk to you all based on my very 25 plus years experience of doing environmental enforcement and negotiations. And so let's jump to it. What I really want to talk about, I guess, what's so unique about negotiating and litigating with the government, and this is in particular on enforcement, is just the most important thing. I think the message I want to get out is just understanding the power dynamics and how they are truly so different. And I should say, I'm someone who, I started out my career representing industry. I've represented the state of California. I've represented the United States. I've represented communities under justice, and now I'm representing EPA. So I say that coming from a place where I have negotiated on behalf of industry and I've negotiated on behalf of communities. And it's really, I'm talking to you a lot though, in this role, in this talk, about being a prosecutor, which I was for 15 years. And so I think the big thing is just understanding that your leverage is very different. And that's going to change how you come to a negotiation, as opposed to when you're coming to it with a private party where you may have a breach of contract or you may have a land use planning issue or thing. Not that at all minimizing the importance of those, but you're understanding the leverage you do or don't have is what I wanted to talk about a little bit, because it does change how you approach negotiations. Next slide. So the first thing I just want to talk about is sort of understanding the components, really the components of the case.
Actually,
and then
Stacey,
of course
you wanted the next slide first. Let me do that, right? Don't you?
No, this one's good. No, this is what I wanted. I wanted that one.
Great.
You all did it. Perfect. You did it. Thank you all. I want to talk first about the components of the case. Like when you're suddenly representing a party that has now gotten, something's happened where an enforcement authority is now looking at them, right? And you've been brought in. Understanding not just the components of the case, but also the settlement. But what you really need to start looking at and understanding is really, and it all goes to the authorities that the enforcement authorities have, right? Is first of all, looking at your statutes that your client is now being said that they violated, right? And that's going to, right, that alone is going to direct and help you understand, to be honest, what kind of leverage you have in negotiations. So for example, some of our environmental law statutes are strict liability statutes. That means it doesn't matter how or why the thing happened. You can be strictly liable, for your client can, for that action. That is going to substantially change potentially how you enter a negotiation, in great part because you just don't have as much of a hand to play. So understanding that, negligence, these are all the thing about environmental laws. You know, we so didn't want that polluted water to go into the bay or go into the air that we literally, Congress set up intent standards that are they're lower than most traditional enforcement cases, and especially crimes, environmental crimes. So for example, negligence can be both a civil and criminal offense in many of our environmental laws. And negligence is really just that, ordinary negligence. You know, it's a reasonable duty of care, and did your client breach it? And it's not that big a standard. So, or willful conduct, that's a higher intent standard. So that's going to make it harder for the enforcement authority, for the prosecutor to have to prove their case if it's criminal beyond reasonable doubt, or if it's civil for preponderance of the evidence. And these are places and opportunities where you're going to be able to maybe put forward a negotiation, or put forward a settlement, or put forward a discussion, even potentially pre-enforcement action. And again, depending on what your client is looking at, but just understanding that some of these are really hard, like strict liability. And so you're really going into sometimes mitigating damages mode, really. It's just how can you, because you're not going to necessarily be able to get out of liability. The second thing is penalties. As many of you know, as I understand the audience, is what is the client's exposure? And in environmental laws, depending on the offense, you're looking at really high maximum penalties. So you have a very high ceiling that can be started with. Now, generally speaking, no one's going to get, I had cases where literally they were looking at $1 billion sometimes, and the biggest cases, or 5 million or 100 million of a maximum penalty exposure based on what the facts were and what the offenses were. Now, of course, that's not what a court is going to give, but it does give, it makes it again harder to start assessing what is going to be a good proposed settlement. And you also need to look at what your floor is. The floor in terms of what your penalty exposure could be, because many environmental statutes have mandatory minimums for certain offenses or violations. And so understanding that going in, looking at what the exposure is, the likely exposure and the maximum or minimum exposure can really help you out as well when you're approaching settlement. Injunctive relief, that is almost generally always going to be sought, at least in an enforcement context. And so what I recommend, and what I think is what I like to see, is when you have a lawyer and a client who are being very proactive on that front, that they have truly thought ahead, that the minute they realize the client is facing some exposure and some liability, that they are getting the things in place, one, to stop the harm quickly. And I should say, like, when I was taught as a baby prosecutor, you know, what my job was, it was when something comes to me, it was stop that harm, restore the harm, and come up with the appropriate relief that will, one, ensure deterrence, not just for that company, but for the industry, and then also give the proper relief, things like, you know, mitigation and things like that. So I would just say the more that the company you are representing, the more that you can come to the negotiating table, already having undertaken several things to start changing your operations, to get into compliance, to improve compliance. That is all going to benefit you at the negotiation table when you are up against an enforcement authority. And then supplemental environmental projects. Same thing. What Kevin was saying was absolutely true, and I'll talk about that in a minute. But you know, when engaging with the community, most times when you have a violation of environmental law, there's someone who is harmed. It may not be a direct harm, but there is a community that is harmed. And so one of the goals of environmental enforcement is to restore that harm, which is often hard to do, because if you've been polluting in the air in Richmond for 5 years, it's very hard to try and directly show how a child was harmed by that her asthma was caused by that. But there are things you can do to restore that harm, and that's where supplemental environmental projects come in. That's a very important role they play in something like environmental enforcement, where it's very hard to show sometimes that direct causality between the pollution and the actual harm to the individual. I say, so the more that the lawyers and the clients are thinking about that, and coming to the table with ideas, the more you're engaging with the community that's been potentially harmed, they often may have ideas of what would be good for them. I've done things like, you know, in my past, I've done probably over hundreds of SEPs in my career, criminal and civil. And there's some of them I'm really proud of: asthma vans, or electric school buses, or monitoring, blood testing. Like, there's things that the community could want. So the more that the defense, well, you are the defendant if you're potentially coming up against a prosecutor, but the client is thinking about that and coming to the table with that. Again, that is such an affirmative effort that shows good faith effort to try and correct the harm, get to a good place, and that's going to be taken into consideration by the government. Is this a good corporate actor that you are bringing to them who really wants to solve the problem? Last thing I'll say on that is EPA just announced last fall an email. It's an inbox that we now have, a supplemental environmental project inbox. Anyone can put ideas into it, including communities. So should you get into a situation like that, know that's a resource of potential ideas of supplemental environmental projects. All right, next slide, please. I can't tell I'm doing on time. I'm trying to be done in 5 minutes.
Doing just fine. Doing just fine.
Okay. And so the other thing to think about when you're negotiating against the government are just the parties generally. So first of all, as Kevin was saying, engagement with the community is critical. I will say under the Biden administration, there are now policies, EPA now has a policy, and the Department of Justice has a policy and documents about how to be engaging with communities, how to be doing, and it's really all around environmental justice efforts and really trying to, so the government is doing it more itself. And so the more that the company is doing it, and maybe even before they've gotten to a place where they're suddenly violating the law, if Kevin's, clients are people who created a project where they were already engaging with the community just to get the project permitted, and then they get in, there's some violations later, it very well could be that effort that they did to build a relationship with the community is going to help them and serve them should they suddenly get into an enforcement situation. But that is, I think, incredibly important. And it's something you want to do, I think, both before and during and even after there's an enforcement action or a settlement or some type of settlement that's been put out there, because you likely will have obligations to that community, whether it's through mediation or supplemental environmental projects. Interveners, I just say something to always be mindful of. Who you expect the interveners to be. Interveners in cases, this is mostly civil, only civil. What role could they play in negotiations? What impact could they have? Are you going to be thinking about how you want to treat them, either pre-enforcement action or during? Would you oppose their intervention if they sought it? You want to think through these things, or whether or not you want to be open to interveners. It could be the communities, it could be nonprofits, it could be trade associations, it could be unions, it could be a lot of people who have an interest, and that can really impact potentially a negotiation. And that's part why I say, even if you get into ADR at some point in an enforcement context, those decisions about who do you want to sit at the table. There may be laws that say who should sit at the table, and like any negotiation, you can often bargain around, and you can have people at that table who you think would be appropriate. So you do have, I think you can have flexibility there, and you want to think about that really strategically. Always being aware of, I think, parallel tort proceedings. We often see that in environmental violations. I, in particular, having sadly I became like a disaster prosecutor, unfortunately, because I had so many disasters, oil spills, explosions, tire fires, things that I ended up doing in my career as a prosecutor. And now, actually, there's often going to be a parallel tort proceeding, and how does that potentially impact settlement discussions with the government? Just being mindful of that. What's the allocation of funding to the victims? What is the allocation of funding potentially in damages, and how does that relate to maybe ability to pay for penalties, things like that? So it's something you really need to be thinking about and potentially coordinating on. It's not always the same lawyers defending both. And then the last thing is just what I kind of would call this collateral, well, collateral consequences is what I was thinking of. I should have had that be collateral consequences. But one of them is the impact of insurance coverage. And I just wanted to say that I know it was something Gideon was interested in and how that can come into play when you're negotiating. I can't say much about it except to say certainly in the disaster, some of the disaster cases I did are very large cases against large companies. Insurance coverage can have an impact on how settlement goes, especially when you're doing if you're doing an environmental crime, or a civil enforcement action that very well could have a larger intent standard than, say, straight negligence. And that's because obviously some general liability insurance won't necessarily cover willful conduct, gross negligence, things like that. And so you have to be very mindful of that. And I've certainly seen some of my cases impacted by that. And the last thing on collateral consequences you should be thinking about when you're negotiating, and what you need to be thinking about all the time, SEC disclosure obligations, debarment, how that could be impacting your client, depending on whether they're looking at a criminal or a civil action, and really reputational harm. That's like a not very concrete collateral consequence, but it's something to be thinking about when you are trying to navigate the best resolution for your client is factoring in this very maybe more indirect, but incredibly critical component, I think, of a company, which is what's their reputation and what is the harm from this action and how can you mitigate for that.
Okay,
and then Gideon, did you want to ask me a question? Because I had some notes wrote up.
Yeah, thank you very much, Stacey. And we're talking about bargaining a little bit here, and hope it doesn't matter to you that we have almost 300 participants listening in on this question. But let me ask you if you have an example or lessons learned for the lawyers out there. Is there a case or an instance where perhaps you were, as a prosecutor, persuaded to drop a case, or the defendant got a good deal? Any examples or lessons learned for the lawyers out there listening today?
Yes. So in my career, I've obviously prosecuted tons of cases, but I've also declined a lot of cases or had them be referred elsewhere, maybe from a federal case to a state case, from a criminal case to a civil case, or just outright declined. And I will say there's one example I can think of, and I'm not going to name names or anything like that, but I will just say it was a lawyer. It was a case that was a big case. It was against a municipality, and the client, the lawyer came in early in the process. So we were still investigating and preparing what we thought was a good case. They came in 100% prepared. And what I mean by that is they had done their own investigation already into the facts. They'd done their investigation into the law. I should say a lot of companies often will bigger ones will do internal investigations. I highly recommend those to the extent it's a company that's a big enough company to do them. Again, you're trying to uncover the facts just like the government is doing. What is the facts? What are the violations? So that you can be informed in terms of how you approach the government. And this person had done that. So they were at a place where they were actually almost ahead of us in terms of where we were in the investigation. They brought in the science. They brought in the science in terms of some of the facts that we were going to need to prove for our case. And they really challenged a lot of our assumptions that we were initially making, and based on what we had seen to date. And they also brought in the equities, meaning often it is important to bring in the equities and I mean equities meaning who is the defendant. In this case, it was a municipality, meaning, if there was going to be some large penalty, it wasn't going to go to a for-profit company necessarily. It was going to be going to ratepayers or taxpayers, right? Or what were the hindrances and obstacles to this company that was making them be in violation of the law? So they really brought in some of the equities surrounding what could have got them to the place of the violations of law. And again, anytime you can show, I think that this is a good corporate actor who had good compliance programs in place, that they really had done all they could and set up a system or a structure that they could show to the prosecutor, look, we are putting money into the nonprofit generating part of our business, which is compliance, not just the profit generating part, to be in, which you could argue is also profit generating. But I would say that was someone and showed all these things. I will say that ended up being a matter that I decided to decline. And I can say the same thing with negotiations. Some of the tips I would say, so this person brought in an amazing PowerPoint. It was really impactful. Often what we see are white papers. Good defense attorneys will bring in white papers up front that allow them to tell their story of how they are seeing the facts, how they are seeing the law. I would say, so that's another, I would say, a tip. I had a sort of don't do tip. I don't know. This is just me. I remember one time talking about equities. One time, I think a defense attorney came in and arguing equities, wanted to argue they were a public company. And so any major multi-million-dollar fines I did really didn't go to the company, but the shareholders. Maybe that would work with some, wasn't quite as convincing to me. But these are things you can think, these are just things you can think through. And then the last thing I will just say is, it kind of goes to what Kevin was saying, is really in any negotiations, credibility is everything and your reputation is everything. Never think that prosecutors, enforcement attorneys, attorney generals don't talk to each other, just like judges talk to each other. Don't think the judges don't talk to each other in the lunchroom. So how you show up is critical. It is relational because, and I just can't emphasize that more. And as long as you are a straight shooter, and you come in and you are that way, that is going to get you so far with any, I think, enforcement attorney. And that's all I have.
Great advice. Thank you very much for that, Stacey. We'll turn now to the third panelist, Richard, who is going to discuss the plaintiff's perspective. Welcome, Richard.
Thanks, Gideon. And my experience has been almost exclusively on the plaintiff side, representing nonprofit groups, community organizations, labor unions, neighborhood groups, but always on the plaintiff side. So that's all I can really speak to. So I'll talk to the challenges about settling cases, negotiating cases from the plaintiff's lawyer's perspective. One of the issues you have as doing what I do is you're often representing an organization. It may be a neighborhood group with 20 or 30 members. It may be a nonprofit organization with thousands of members. But it's hard to sometimes say, what is the opinion of the group? So I think when you go into a negotiation, you need to know, what does your client want? What is their goal in the negotiation? So I often try to meet with the leadership of the organization, talk to them about what the case can possibly get if we litigate it. You know, what's the best scenario if we litigate and win? And how strong is the case? But I also like to have one point of contact. So all of our representation agreements require the organization to appoint one person. And this is the person that I talk to find out what is the opinion of the group in terms of litigation, settlement, big strategic issues, because I don't want to have to talk to 20 people every time we make a decision. And so the organization has to assign that person, and then it's that person's duty to talk to whoever they need to talk to figure out what their position is. Now, understanding your client's goals would be very different if it's, say, an environmental organization, a big environmental group, or a community group of people who live near a facility, a labor union. All these different groups are going to have different goals and in the litigation. So it's really important to understand what those goals are as a lawyer going in. It can also be difficult if there are many groups involved, especially if the lawyer is representing many groups, which often happens. I know where Stacey used to work at Earth Justice, sometimes they'll have 5 or 6 environmental organizations they're representing, and our firm does that on occasion too. That's tricky. That can be because they don't always agree with each other. So we often try to avoid those situations. It's best if you're representing one organization, but if there are multiple organizations, it's really important to meet with them up front and get on the same page. It's also important as a plaintiff's lawyer to realize litigation is not your only tool. A lot of times these groups will have a media strategy to reach out to the press and put out press releases, hold press conferences. They may have an organizing strategy where they can hold demonstrations and rallies outside of city council meeting that may be held on a project. They may have scientists who can release reports about the risks of a particular project. And they may lobby, meet individually with their city council members or their planning commissioners. Those can all be very effective strategies that community groups sometimes are better at than defendants or government agencies. So that's those are all strong tools. It's important to know going in, like, what are your tools and how strong is each tool? The litigation tool may be a very strong tool, but the other tools are also strong. It's also good to know what are the litigation angles. You know, I know a lot of lawyers are kind of one-trick ponies. They may just be Clean Water Act lawyers or just CEQA lawyers, and all they do is CEQA. But it's important to, I really think plaintiffs lawyers have to get better at learning the whole menu. There's not just CEQA, there's the Clean Air Act, there's the Clean Water Act, there's Proposition 65, I've brought nuisance law cases in certain situations, RCRA, and to kind of know the whole menu of options so that sometimes CEQA might not be your strongest tool. And if each of these laws has strengths and weaknesses and limitations. Now, I was going to try to speak, I'm looking at my time here, briefly about a couple of case studies, because I always, I'm a case study guy. I think it's a good way to learn things. One is a pre-litigation case it's going back in history here, 1993, kind of towards the beginning of my career. I was legal director of Communities for a Better Environment. Chevron Richmond Refiner was planning a major expansion. And we brought together, it was called the Clean Fuels Project, which actually was intended to make cleaner fuel for California. The problem was it would result in more pollution for the city of Richmond. And so my organization, CBE, worked together with community organizations in the city of Richmond, the West County Toxics Coalition. There were neighborhood organizations, there were labor unions involved. It was a very large coalition of groups that had concerns about the project. And we started out by bringing those organizations together and developing a common list of demands that everyone was going to support jointly, which included pollution reductions, very significant pollution reductions from the refinery, but also the community wanted a community health clinic and a warning siren system and a community foundation. Now, these were really important goals for the community. There are also things that we couldn't, I was explaining, it's highly unlikely you could get those even if we won a CEQA lawsuit or a Clean Air Act lawsuit, which were the two legal structures that were involved here. So it was really important to get these through either political lobbying or through negotiation. So the community put together this community benefits package, which was, I think we called it the 20-point plan, had all these different points. And they lobbied very hard, both met with every single city council member, every single planning commissioner, had a media strategy, had a door-to-door strategy, packed planning commission meetings with members. And lo and behold, we won a unanimous ruling at the Richmond Planning Commission. They adopted the entire 20-point plan, which I think surprised Chevron. Chevron then kind of redoubled its efforts and started lobbying the city council. And unfortunately, we lost at the city council. And so the city council gave some of the measures, watered down some, and kind of gave us half the loaf. The community then met and decided whether they wanted to sue under CEQA. And somewhat to my surprise, they decided not to, because they thought, well, if we win under CEQA, what do we get? We get a new EIR. We don't necessarily get these things that we really want. And so instead, we shifted our focus to the Bay Area Air Quality Management District and filed an appeal at the hearing board under the Clean Air Act, new source review provisions. And that was a very extensive process about what is best available control technology for this project. And that was clearly going to drag on for months and months, and Chevron was under a very strict timeline to get this project up and running. that ultimately brought them to the negotiating table. The Air District appointed a mediator to negotiate the case, and we got a very good result with pollution reductions, warning system, community health clinic, community foundation. And none of that would have been possible even if we had litigated under either CEQA or the Clean Air Act. See, I'm short on time. The next one is a case that was litigated in fairly recently, 2022. The largest warehouse in the United States, actually 40 million square feet. It's like 700 football fields, I think, would fit inside there, out in Moreno Valley in Riverside County. This was a CEQA proceeding. It also involved multiplicity of parties, environmental groups, community groups, labor unions. Our firm was representing a labor union in this case. It involved 8 years of litigation, 2 trips to the Court of Appeal. Earth Justice, Stacey's group at the time, was involved. The company was very reluctant to engage in settlement discussions, but ultimately, after losing twice at the Court of Appeal, did come to the table. We brought in a very good mediator and got an excellent settlement that I think is kind of a model for other warehouses involving solar panels on the roof, clean trucks, electric vehicle charging, $4 million for the local wildlife refuge, and community concerns like a buffer and a berm, noise proofing, air filtration for neighbors' houses. On the labor side, it's clean construction equipment. There was a labor agreement. So all the way around, it was a good outcome. It's unfortunate that it took 8 years of litigation to get there. So I wish that the parties had been able to communicate seriously earlier, but we did get to a good outcome. So, take home lessons, focus on the client's goals. Know what are your client's goals? What do they want? Even if it's not possible to achieve exactly those outcomes in litigation, a strong hand in litigation may be able to allow you to get those goals through negotiation. We find that sometimes it's useful. In this Chevron case, for example, we locked the lawyers out of the settlement room. One of the lawyers we found to be very disruptive, that it seemed to us he just didn't want to settle. So we said, let's lock the lawyers out, put the clients in the room with the experts, with their scientists. And they came out with a very good settlement that I think the lawyers would have it may not have happened if the lawyers were involved. And also have good consultants. Consultants can often, talk expert to experts and come up with very good solutions that are feasible and reasonable and can reduce pollution or address the concerns of the community.
Rich, talk for a second about the early CEQA settlement meeting. What's been your experience there? And do you agree that this is something that we can do a better job with, trying to really settle the cases?
Yes, honestly, it's in the statute. People do it because it's mandatory, and I think it's almost always a waste of time. Part of the reason is, even though the statute says the clients have to attend, there's case law saying they don't. And so people don't come with their clients, and the lawyers go in there and they talk about case scheduling. No one's really talking about settlement. I think also it comes too early in the case. Usually it comes before the administrative record's even been prepared. The lawyers don't really know the merits of the case that well. I think it would be more productive if the clients actually had to attend, and if it were somewhat later in the process. I know it's early because they want early settlement, but it's just not, when the parties don't really know the merits of the case, it's very hard to settle.
Got it. Yeah. And I love the slide here, which is this iceberg. We all see the iceberg. We see what the allegations are in the complaint, but it's below the iceberg. What are the interests and goals of the parties? What's beneath the surface? That's where you get to settlements, the creative settlements in these cases, where you can get more than you could if it goes to judgment. So I really do like your slide here. What's below the iceberg? We're going to finish up back to me with just a couple quick mediation tips. We figured this is a presentation with ADR services, so let's go through this. Tip 1, take a refresher look at the California Evidence Code section 115 et sec mediation provisions before your next mediation. Review the expansive confidentiality provisions They're more than just the regular settlement privilege. Also, do you know what is the magic language and requirements to make a term sheet signed at mediation enforceable? Tip 2, always insist your mediator has a pre-call with each of the parties, usually separate. You will teach the mediator, flesh out things that need to be addressed before the session. You don't want to waste time or be unprepared at the session. 3, chit chat. It's important to build rapport. As a litigator, I used to hate it. Now as a mediator, I love it. It should be authentic, and it's critical to building trust and likability. It can be anything: children, vacations, artwork. Understand why your mediator is doing this and aid in the effort. Anchoring. Anchoring is key in mediations. Who puts out the first number often anchors the entire mediation. Be aware and mindful of that. Defendants often ask plaintiff to make the initial demand. Why? Is that always right? 5th, mediators listen very carefully to the word no. No can be extremely helpful, actually, to understanding the parameters of a deal, to explore other options. Don't be afraid to say no, but when you say it, you must mean it. There's research on this, a great book by an author named Jim Camp. 6th, the mediator's job is to explore the parties' positions and preconceptions, to open minds and seeing other ways of the dispute to encourage the parties to move. There's no way that's better to do this than through open-ended, clarifying questions. How? What? Why? You may hear a mediator ask the word why over and over, digging down to try to change preconceptions. You should expect these. Your client should expect these from the skilled mediator. 7, yes, mediation's about settlement, but there are other things where maybe a mediator can help. Do we need a deposition date, a stipulation? You can use mediation as a facilitated meet and confer or status conference too. 8, reciprocity is so key to influence. There's a great book on this called Influence by Robert Cialdini. Even little things, holding the elevator for the other side before the mediation, agreeing to small concessions, even if it's just on timing, for example. It's human nature to respond to reciprocity in kind. Remember that when you're mediating. And that leads to momentum. One of the great aspects of mediation is the emotional salience of the process. Momentum can occur as we get late in the day, as we get closer or closer. Cases settle, concessions are made that you would not believe. It's what the scholar Ken Cloak calls the magic of mediation. And finally, always work with your mediator as a trusted partner. It's candor about your client's true goals, interests, and demands that helps the mediator make them happen. It's okay for the parties to tell the mediator things they would never tell each other, and only then can the skilled mediator strategize with you about what to communicate to the other side. So I want to thank all of our panelists as we're getting close to 1 p.m. on a Friday afternoon for Earth Week. Kevin, Rich, Stacey, thank you for joining me today. Thank you for joining our almost 300 participants. A big applause for you folks. Thank you very much. And want to thank everyone for participating today. And we'll see you at the next mediated case. Thank you very much.
Thank you. Pleasure to be here.
Thank you, everybody.
Wonderful. Thank you speakers, panelists, and thank you everybody for joining us today.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.